All right, we are walking into a real probation revocation hearing, and I need you to pay close attention because what's about to unfold is a masterclass in how quickly one bad decision can unravel years of second chances. Stay with me.
I show that it was reset. That's okay. Okay. It's all good. Mr. Lewis, you've got Avriona Dorsey.
I think I need to sign that, Your Honor.
Okay, I'll call it as soon as she's ready. Do you need, oh, she's already doing another one. How about Kenneth Harrison? Mr. Lewis? Harrison. Morning.
Hey.
How are you?
Oh, no,
Good morning. Are you Kenneth Harrison? And will your client waive the formal reading of the motion?
He does.
Mr. Harrison, in cause number 24 DCCR 0544, I have a first amended motion to revoke your unadjudicated probation. This shows that you were placed on probation November 19th of 2024 for the first degree felony offense of aggravated robbery. And that was a 10-year deferred probation. Is that correct?
No.
The motion alleges that you violated your probation. Count one alleges that you failed to report as directed on or about March 31st of 2026. And is that true or not true?
True.
Count two alleges that you failed to work faithfully at suitable employment and provide verification of that. Is that true or not true?
True.
Count three alleges that you provided a urine sample June 24th, August 27th, October 30th of 2025, and March 9th of 2026 that tested positive for tetrahydrocannabinol. And is that true or not true?
Your Honor, I can abandon 4, 5, and 6. We can skip to 7.
Count seven, let's see, state abandons 4, 5, and 6. Count seven alleges that you committed the new offense of failure to identify a fugitive or give false information on July 13th of 2025. And is that true or not true?
True.
Count eight alleges that you associated with a convicted felon and disreputable person on July 13th of 2025, and that you were stopped by the Port Arthur Police Department with Gerodric Randall, a convicted felon, and that he fled on foot while possessing a weapon. Is that true or not true?
True.
Let's pause here because this is important. True or not true? That's not sloppy phrasing. In a probation revocation hearing, the standard of proof is much lower than a criminal trial. The state doesn't need proof beyond reasonable doubt, just a preponderance of evidence. And when a defendant admits counts are true, that's essentially a guilty plea by a different name. Count by count, this case is building fast.
Did you enter your pleas of true to counts 1, 2, 3, 7, and 8 freely and voluntarily?
Does not.
And did you plead true to those counts because they're actually true?
Does not.
Well, give me just a second.
Your question would be the underlying offense, Your Honor.
I'm just gonna go back and look at the PSI real quick.
He was one of 4 individuals that were breaking into cars. When they got caught, one of them fired a shot at the person who confronted them while they were breaking into cars at a parking lot. Put everyone on probation. They've all come back, Judge.
I guess my concern is that there was obviously a gun and a shot in the underlying offense.
I do recall Mr. Harrison not being the shooter. I think we were able to figure out who.
That he's in another gun? I mean, another car with somebody
Yes.
with another gun?
And Mr. Randall's been revoked and sentenced to 8 years. He had a drug case, a new felony, so which is why his was a little bit more.
Look at something else.
Did you catch that? Harrison says the counts are true, and then immediately says they're not actually true. That is a five-alarm moment in any courtroom. The judge has to stop everything because if a defendant doesn't actually admit guilt, you can't accept the plea. But wait, it gets more complicated. His co-defendant Randall just got 8 years. And Harrison? He was in a car with yet another gun. The judge is clearly doing the math, and the numbers aren't looking good for Mr. Harrison.
Do you happen to have the PC for that? The new
For his new event,
Daddy.
yeah.
I do, Judge. I also have the report from Mr. Randall's charges from the same stop. if you're asking as far as where going was.
Yeah, that's
Mr.
what-
Randall's lap as he ran from the vehicle and fell out as he ran.
Obviously, I'm just having some concern.
I understand her.
Yeah, obviously, we're all over. Can't tell you how over we are with guns. And the fact that this is the second out past curfew with in a car doing whatever you're doing that you shouldn't be doing with another gun.
I will state, Judge, it was at about 6 o'clock in the evening. I don't think it was past.
Oh, it was?
No.
I'm sorry, I thought I
It
read
was- it
something
was-
about curfew. That was
Not this one, Your Honor.
Okay, thank you, Mr. Nick. I don't guess it really matters what time it is. And the other three that have already been revoked.
Mr. Randall received 8 because he was in possession of a firearm.
So was he one of the original
I think so, Judge. I do know that.
co-defendants under the underlying case as
I
well?
believe that's why he wasn't supposed to be hanging out with him. And then,
That would probably.
there's
be- It'll have in here.
yes, Your Honor, he's one of the original.
Okay,
One
I'm
of
not
the
gonna,
co-defendants.
yeah. Five's not, I'm not gonna accept 5. Not if you're already on probation with the same person for aggravated robbery with 3 guns in that car, another gun in this car. If he got 8, then I would consider that, but at this point,
We'll discuss it. Your
I'm
Honor.
over all of this gun stuff. So I'm gonna, I'll keep, I guess, the paperwork for now. If y'all come up with an agreement,
Yes.
otherwise it's a motion to revoke. I don't have to accept any agreements. It can just be up to me and we can have a hearing if we have to. But I'll just keep it for now. I can make an adjustment if you guys come up with something different.
Okay.
All right.
Thank you.
Goodbye.
That right there? That's a judge putting everyone on notice. She just said, I don't have to accept your deal. I can take this to a full hearing and decide everything myself. That is a massive amount of judicial discretion, and it's perfectly legal. She's essentially telling defense counsel, come back with something better than 5 years, or I'll decide. The punishment on my own terms. The defense just had the floor pulled out from under them, quietly, politely, devastatingly.
Mr. Parker, on Dontrell Robertson, you're asking for some more time on that?
Yeah, we're just gonna try to work the case out. It was set for a bond hearing.
Okay,
So we're gonna pass on a bond hearing. We're gonna try to get the case worked out.
today?
No, I
just
don't have all
that.
the information yet.
Okay,
Get the
so
new case.
we'll reset Dontrell Robertson, just a
Yes.
normal reset. See. About Brent Smith.
Well, that should be papers.
Okay, I don't have them yet.
Oh, really?
Do you have papers for Brent Smith? Okay, thanks. We can go ahead and get Mr. Smith. I'll take care of it next. Brent Smith. You need to fingerprint him? Yes. Okay. Mr. Smith, if you'll step in front of the clerk first real quick so she can swear you in and take your thumbprint.
Drug course, but it's supposed to be substance abuse on the ISF.
Oh, I don't see it yet. It's supposed to be ISF substance.
Yeah, I just put drug.
Oh, okay.
ISF drug.
Oh,
I mean,
I figured you knew what he was talking
I just thought of that. Looked like it. Right here.
Good morning, sir.
Hello.
Are you Brent Smith?
That's correct.
And will your client waive the formal reading of the indictment?
Here we go, Your Honor.
Mr. Smith, in cause number 26 DCCR 0128, you're charged with the second-degree felony offense of burglary of a habitation from December 20th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 10-year deferred probation. There would be a $500 fine, and you would be required to enter and successfully complete the substance abuse track of the ISF program. Is that your understanding?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number
No
1.
objection.
It's admitted. Is there any evidence that Mr. Smith is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case. We'll make sure that we have everything in place, in addition to an ISF that you need in order to be successful. And then we'll come back for sentencing at a later date. All right, you can go back with the bailiff. Well, Donald Druso.
I didn't think that's what.
Okay. Okay. Let's do you have a sentencing?
I
No.
have Victoria Bailey for.
Let's do Victoria Bailey. It's a sentencing. Victoria Bailey.
So I have Mark Hebert. We're just gonna go through the motion.
Okay. Thank you. Good morning, ma'am. Are you Victoria Bailey?
Yes, ma'am. Good morning.
And Ms. Bailey was previously here in court in cause number 25 DCCR 0278, entered a plea of guilty to the third-degree felony offense of assault on a hospital personnel. And I've received that pre-sentence report. Have you both had an opportunity to review the report?
I have, Your Honor. Yes, Chief.
Are there any additions or corrections?
None more objections.
All right, Ms. Bailey, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. That is going to include being on the specialized mental health caseload. That'll make sure you have anything you need in order to be successful. So you can get your any drug treatment, mental health treatment. And it's important that you follow through with everything that they recommend. Even if you don't think it's necessary, it's going to be court ordered that you go through whatever program probation says you need to, okay?
Yes, ma'am.
This is a great opportunity because you do not have a felony conviction on your record. And at the end of the probation, if you're successful, the case will be dismissed and you'll never have a felony conviction. So it's a great opportunity.
Yes, ma'am.
The other side of that opportunity, though, is that if you violate any condition of probation, you can be brought back into court and you can be found guilty and sent to the prison for between 2 years and up to 10 years. Do you understand?
Yes.
I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. It looks like I will be signing also a dismissal in clause number 25 DCCR 0170 as part of that agreement. All right. Good luck to you, ma'am.
Thank you. Thank you so much.
And that's a wrap on this docket. 3 defendants, 3 completely different outcomes, and 1 judge holding the entire balance. Brent Smith gets a deferred sentence with a path to dismissal. Victoria Bailey walks out with probation, a clean record still intact, and a second chance she clearly felt deeply. And Kenneth Harrison. He's heading back for more negotiations with a judge who has made one thing crystal clear. Guns and repeat violations are not something she's willing to overlook. Think about this, the difference between walking free and years in prison often comes down to what happens in these quiet morning hearings. No cameras, no drama, just a Judge, a defendant, and the weight of a decision that can change everything. What would you have done in her position?